Okay, lengthy scenario. And I'm not going to focus on the history. I appreciate the history. It sort of helps me. I'm going to focus on the fact that you have been in a due process situation, and and I do appreciate your patience. I know you asked this question, a few months ago. Yeah. So I don't know what the end result is with regards to your hearing and what the hearing officer or judge ruled with regards to these options. Now, what I'm going to explain and what you would ask is sort of a second opinion. Well, you have representation, or you had representation at the time, and at that point, you can't really do that. But what I'm going to do is take your scenario, and for the other parents out there, so that they can sort of understand how this process works, explain the various components, all right, in the world according to James, in this maze of the IDEA, because it is. And you think you're going this way, and then you reach an obstacle, and it forks to where you have this way to go or this way to go, and you go this way, you might run into 5 more obstacles along the way and end up having to turn back to go this way. And I know that doesn't help anybody. I know it doesn't make anybody happy. I know that it is not what parents want to hear. But I'm telling you, when you're dealing with government money, even though it's our money, and even though you're dealing with the general incompetence of government, because it can't balance budgets, it doesn't manage any program very well, except for killing people. It's very, very good at that. But any other safety net program, it's just not really good, and fraught with abuse and fraught with corruption, and overspends, and you just don't get that good of an out product on anything the government does. All right? I mean, it just works up under a different theory. Now, what I do like about government is that we have situations to where, we have these civil rights laws that are there. And, those I like, and those I work under, okay? Because there are mechanisms to create corrective action. And due process is one of those corrective actions. Now, what parents don't understand is that, when all this crap was happening way back, with these programs 5 years ago, and what they were trying to do then, parents need to understand that at that point, if the school system is moving forward on a program that you disagree with, and you don't do anything about it with regards to triggering your dispute resolution options to challenge those decisions, then there's sort of a presumption that you agree, and sometimes you do, and sometimes you don't know how bad it is because they've sold you a crap, until the school year's gone. And yes, you do have a 2-year statute of limitations, or a 1 year, depending on where you live. And you said you put in here that you're in North Carolina, so that's a 1 year statute of limitations, not even a 2 year. Most of the country is a 2-year statute of limitations. So you have a 1 year statute of limitations. So that 5 years is other than you can provide the court a history of what's been going on, but at the same time, where's your corrective action? Well, your corrective action is limited to that 1 year. Where's your child been for that 1 year? What's been going on in order to justify and provide you that background or that ability to it's the counterweights. You're wanting this. Well, what was so severe over here that this, that it justifies a judge giving you this? And I believe that you're justified, but at the same time, this is one of those things to where, like I said, like a maze, you've got to know which direction you're going, and you need to know how to argue that. So if these programs were what they put him in, and you did not trigger the dispute resolution options, meaning through an attorney through a good advocate, through using mediation, through using due process, through using the facilitated IEP process, any of those, to sit there and try to rectify these bad programs here, then like I said, you just, it doesn't necessarily put you in the position that you would need with every hearing officer to justify the private placement, especially one that they're claiming isn't, a school, and quite frankly, there's case law out there. It doesn't matter. It's just BS to sit there and claim, well, they're not accredited or whatever. Well, is your kid going to Harvard? If they haven't been able to successfully help your child in all areas of your child's educational performance, and I'm just talking about the Andrew F. Supreme Court standard that we go off of now, the law's always been there, but as far as how the schools have been getting away with applying it to where they only look at academics and they sort of diminish the other educational performance areas of functional skills, of communication, and of social emotional development, which would include behavior. Well, see, that's a problem. And academics be damned, because if your child's just caught in this cycle of not being able to attend, not being able to participate, not gaining any benefit from the instruction, then it's because they haven't dealt appropriately with the behavior and the other aspects of your child's program. So that takes you back to that whole base level, to where you're doing a comparison with their offered program. Or what I'm saying is what that program was before, and then what it is that works for your son. And this is where it gets really nasty, okay? Because now the school system is coming back and they're making you an offer saying, well, we can make this appropriate for him. We can bring a behavior analyst in and consult, and we can have your child with a one-to-one aid. Well, there's nothing in the law right now that dictates that it has to be an RBT. Now, can a one-to-one aid be trained to a level of competency comparative to the RBT standard? Absolutely, and I use that all the time in my settlement agreements. But you have to sit there and tie the school down to those terms. That the aide has to be trained to a level of competency comparative to an RBT status, to where the BCBA is doing a supervisory role over staff implementation of your child's behavior program in a comparable manner of what is being provided over here at this ABA school. Now you sit there and say, well, why do I have to accept it? I'm not saying you have to accept it, but what I'm telling you is that the risk of you winning, even with an attorney, once they put that offer out there, and because you don't have anything to back up that you have challenged it in the past, then I know parents go, but I've been on this roller coaster, I've been on this mouse wheel for 5 years, James. I get it. I understand that. But this is the first time you've used me. This is the first time you've used a special education attorney to advocate and help correct the situation. So yes, you may have had the situation screw up for you for 5 years, but part of it is your fault for not triggering the dispute resolution measures back then, okay? And that's the part that I'm hesitating on purpose, because a lot of parents don't want to hear that. The dispute resolution things are there for a reason, guys. If you, as half of your child's IEP team, are not triggering those, and you're just letting it happen, then yes, you have that 2-year statute to where you can go back, or 1 year in North Carolina or Texas. But it doesn't mean that you are in a full position to dictate. Because according to the court, this is the first time that you've challenged the school. And so if the school's coming back with an offer saying, we can do it, and they're offering something fairly comparative to what you found over here, then there's a lot of judges out there that are going to agree that you should give this a chance, even though they have failed all these other times, and even though you could probably prove that. But most board attorneys are going to be smart enough to say, well, why didn't you say anything about that? Why didn't you complain then? Why didn't you file then? Oh, you didn't? Oh, okay. Well, you did now, and this is what we're telling you we can do. Okay, we can bring in a behavior analyst. We can give your son a one-to-one aide, and we can train that aide to a comparable level of what you're requesting. And at that point, it sort of shifts over, and I it puts you in a tough spot, and especially if they wrapped it into, let's say, a 10-day offer, because if you don't get more than what they offered you, and you go the distance to hearing, there are mechanisms in there to where the special ed attorney becomes responsible. We get sanctioned if we don't accept 10-day offers that are fairly good. It is the special ed attorney, not the parent, the special ed attorney, because we should know better. We should take these offers. I know that sucks, and I would need a whole nother video to explain that, guys. But it's a 10-day offer, and that's a mechanism that's put in there to keep this thing moving forward and child focused. Because there are parents out there that are in this for revenge. They want blood. Some attorneys are in this to sit there and make money, and that's not the focus. The focus is child driven and child solutions. No agreement's going to be perfect. But at the same time, if it was wrapped into a 10-day offer and you don't take it and you go forward with a hearing and you end up not achieving more, and sometimes, depending on the federal court, substantially more than what was offered here, then the school district can request that the federal judge sanction your special education attorney to where the special education attorney has to pay for the school district's attorney fees, usually from the point that the offer was made. So the fees past the date of that offer when it should have been received. And then not only that, is the attorney loses their ability to get reimbursement on the fees for the parents or get compensated for their fees from that point. Or you just lose them altogether. So it's something you really have to weigh. But at the same time, what that does, in my maze example, is I know that most parents are not going to want to accept that offer because they found something great over here. But if you can't afford that over here, then yes, you have to take this. And then what that does is now you've given them a chance. Now you've given the school system their at bat. And it puts you in a completely different legal position. And it really doesn't take you that long using data collection as to whether this is going to work. And then you still have your data collection from your ABA school where it was working and your child was progressing. And at that point, you can file another due process case. And at that point, man, I tell you what, if you're a school system, you're screwed because you've been given your chance in a court-ordered agreement where you said you could do it. Where you said that you could provide a comparable program to this, and if you fail here, it doesn't take that long for you to have data collection to prove that. And then you file, and you sit there and say, look, I gave him a chance. And it makes you look like Mother Teresa because you did give the school that opportunity. And they squandered it, and they screwed up. And at that point, you're able to hold out your program that you want comparative to this, accredited or not, your child made progress. And if the BCBAs, which that's what I love about BCBAs, are data driven, they're data crazy. They take data all the time. The schools aren't very good at taking data. And you hold those things against each other. But that's where I tell parents, I understand you've been going through this for years, but this is the first time you've used me. And because it's the first time you've used me, then we've got to sit there and be smart about how we approach this, because I'm walking you through this maze. And I can sure as hell guarantee you that I'm not hitting obstacles over here because I can see them. I've been doing this long enough. I know where the obstacles are. And yes, our job is to go over here, and it's not necessarily a straight line. But you stick with me and you understand how this process works, and you understand that sometimes you got to take a step back to move 5 steps forward because it's quicker using my maze path. Well, because you're not having to hit obstacles. And even though you think you're going this way, you're hitting multiple obstacles and you're not getting there. Whereas if you go this way, and it might look and appear to be a longer route, it's not. It's the quickest way to get what you need. But sometimes it's not the fastest, all right? And parents have a problem with patience, and they have a problem with long-term strategy. But that's how this process works, because government is the one making the decisions. Judges all work for government, even the hearing officers. And they're going to be more amenable to an education system that says that they can do it. And if you don't have prior agreements to where they've screwed up, now there are situations, guys, to where, yes, you can make good arguments like that. And I have cases like that, and we make those arguments all the time. I'm telling you, according to this scenario, I can see where a hearing officer would it would be a risky proposition for you to go the distance to the end if the district is offering you something sort of comparable. And if it was me, I would recommend taking it and then setting your goal, making sure the data collection is being maintained, make sure that you have good data collection out of your private facility. Pray for the best over here, but sort of expect that they don't have a clue. They're Captain Cluelesses. And yes, does it mean that you sort of have to free float your son for a little bit? Yeah. It sucks. I've done that with my own child. I've had to do that with my own child in order for me to prove what I needed to prove. That's the thing about courts, guys. It doesn't work off opinions, and it doesn't work off feelings. And this is a highly emotional area that involve our children. And it just doesn't work off of feelings. It works off of fact, and it works off of evidence. And sometimes in order for you to get that evidence, you have to free float your child to show how bad it is over here.